Good evening, friends. We were discussing Order 5 yesterday, and we'll continue with the rest of the rules that we had missed out yesterday, and then we'll proceed to the all important Order 9. So, without wasting much time, let's just start with our discussion. Yes. So, we probably discussed till Order 5, Rule 19. That is, if the court is in doubt regarding the service of summons, then the serving officer may be examined with regard to the fact that whether the summons was duly served or not. That we had discussed. We'll discuss Rule 20 today, which talks about substituted service. So what do you mean by substituted service? That means by not doing the proper service of summons, you are actually, in fact, considering a service which was not done properly a proper service. Basically service टा ठीक रे हेइनी, but आपण सर्विस टा आउ गोटे मोड रे करिकी सब्स्टिट्यूट मोड रे करिकी you are considering it as a due service. So in what case it may be done? Se कहूची जदि defendant deliberately avoid करूची summons नबा ପାଇଁ किंबा ordinary way रे summons serve करिया ପାଇଁ time एते पळेबो or expense एते पळेबो that cannot be done, then in that case the court ଭାବିବ that this is the proper way to go about it, then କୋର୍ଟ କଣ କରିପାରିବ ସବଷ୍ଟିଟ୍ୟୁଟେଡ୍ ସର୍ଭିସ ପାଇଁ ଅର୍ଡର କରିପାରିବ. ନର୍ମାଲି ଆମେ ଜାଣିଥିଲେ ସମନ୍ସ କେମିତି ଦିଆଯିବ. ସମନ୍ସ ଦିଆଯିବ ଆଇଦର ଆମେ ଯାହାକୁ ଆମେ ଡିଫେଣ୍ଡାଣ୍ଟକୁ ଦବାକୁ ଚାହୁଁଛେ ଆଗ ଡିଫେଣ୍ଡାଣ୍ଟକୁ ଖୋଜିବା, ଯଦି ଡିଫେଣ୍ଡାଣ୍ଟର ଆବସେନ୍ସରେ ତାର ଏଜେଣ୍ଟକୁ ଦବା, ତାର ଆବସେନ୍ସରେ ଆମେ ପଢୁଥିଲେ କଣ ନା କୋଉ ଆଡଲ୍ଟ ମେମ୍ବରକୁ ଦେଇପାରିବା. ଆଡଲ୍ଟ ମେମ୍ବର କିନ୍ତୁ ସର୍ଭେଣ୍ଟ ଇନକ୍ଲୁଡ କରେନି ସେଟା କହିଥିଲା. ଏହା ବି କହିଥିଲା that ଯଦି ଅଫିସିଆଲ କାମ ଅଛି ବିଜନେସ ରିଲେଟେଡ ଅଛି ତାହେଲେ ଏଜେଣ୍ଟକୁ ଦେଲେ ଚଳିବ. ଆହୁରି ବି ଏଟା କହିଥିଲା ଯଦି ଇମୁଏବଲ ପ୍ରପର୍ଟି ରିଲେଟେଡ ଅଛି ତାହେଲେ ଚାର୍ଜରେ ଯିଏ ଅଛି ଇମୁଏବଲ ପ୍ରପର୍ଟିର ତାକୁ ଦେଲେ ଚଳିବ. So basically all of this was normal mode of service. But then comes substituted service. ତାହେଲେ କହୁଛି ଯଦି ଡିଫେଣ୍ଡାଣ୍ଟ ଏମିତି କିଛି କାମ କରୁଛି ଯୋଉଥିରେ କି ସମନ୍ସ ଦେବାଟା ପସିବଲ ହଉନି, ତାକୁ ଆଇଦର ସେ ଇଣ୍ଟେନସନାଲି ଆଭଏଡ କରୁଛି ନହେଲେ କଣ କରୁଛି ନା ସେ ଏମିତି କିଛି କାମ କରୁଛି ଯୋଉଥିରେ କି ଅର୍ଡିନାରୀ କୋର୍ସରେ ଡିଲେ ହେଇଯିବ ସମନ୍ସ ଦେବା. If court is of that opinion, so in that case what can be done? Rule 20 says that court will do the following things. Court will do that copy to be affixed in courthouse and visible part of the defendant's last residence or office, advertisement बाहर कर दो local newspaper रे, or any other manner as decided by the court. So these three modes रे भी तीनटा मोड रे भी जदि कोर्ट चाहिबो that ଯଦି defendant deliberately avoid करूची किंबा summons ordinary course रे serve हेई पारुनी, then in that case court can order that this is the way a summons may be served. How କଣ କରିବ ନା କୋର୍ଟ ହାଉସ ରେ ଗୋଟେ କପି ଫିକ୍ସ କରିଦେବେ, ଆଉ ଗୋଟେ କପି ନେଇକି ଡିଫେଣ୍ଡାଣ୍ଟ ର ଲାଷ୍ଟ ରେସିଡେନ୍ସ ରେ କିମ୍ବା ଅଫିସ ରେ କିମ୍ବା ଯୋଉଠି ପର୍ସନାଲି वर्क्स फॉर गेन, in that place you fix it. ଧରାଯିବ କି ସେଟା ସମନ୍ସ ସର୍ଭ ହେଇଗଲା. और advertisement ଗୋଟେ local newspaper ରେ ବାହାର କରିଦବ that ଅମକ ଅମକ date ରେ the defendant namely ଅମକ is required to appear at the court to address the TS suit, title suit number 19 of 1991. If that is done, that will be a sufficient service. Any other manner ଆଉ ଯଦି କିଛି କୋର୍ଟ ଭାବି ପାରିବ, beating of drums ଭାବିକି କଲା, ଗାଁରେ ଆଗରୁ ଥିଲା କୋର୍ଟର ଶୁଣ 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 ଏମିତି କରି beating of drum ହୁଏ ସେଠି କରି ଶୁଣା. ଯଦି କୋର୍ଟ ଡିସାଇଡ କରିବ that any other manner ରେ ବି ସର୍ଭ ହବ, ଇମେଲ ରେ ବାହାର କରିଦେବେ. ସବୁ ଗୋଟେ କଣ ତ କହୁଛନ୍ତି ୱେବସାଇଟ ରେ ପବ୍ଲିଶ କରିଦେଲେ. ଯଦି କୋର୍ଟ thinks that is a proper mode of service of summons, that can be done. Then probably we may see it in the near future. ଏବେ ଯେତେବେଳେ ଯେତେ digitalization ହେଲାଣି, maybe that may be in fact true. The same mode ରେ ବି substituted service ହେଇପାରିବ. So this case, Satish Construction Co versus Allahabad Bank case re, what it has been said that court to record reasons of satisfaction before substituted service can be recorded. So basically, in all cases, substituted service will not be ordered. Ordinary summons service habo. କାହିଁକିନା ନର୍ମାଲ କୋର୍ସରେ ଆପଣ ନର୍ମାଲ ସର୍ଭିସ ଡିପେଣ୍ଡେଣ୍ଟ କୁ ଅଛି ଡିପେଣ୍ଡେଣ୍ଟ କୁ ଦେଇଦେବା ଠିକ ୟାର ନୋଟିସ ବୋର୍ଡରେ କୋଉଠି ଗୋଟେ ବାହାର କରିଦବ ତା ପଛରେ ଘରରେ ମାରିଦବ କହିବ ଯେ ସର୍ଭ ହେଇଯାଇଛି. That is not to be adopted at once. First, you have to find the defendant, in his absence, the agent or any adult member. If you can't do it, defendant is intentionally avoiding the service of summons. Then in that case, ଆପଣ substitute summons ପାଇଁ ଯିବେ. ଆଉ substitute summons ଟା କିଏ order କରିବ? Court order କରିବ after recording the reasons for such order. ତାପରେ the question comes that can a plea be taken by the accused that he does not read the newspaper? ଏଇଟା ବି ଗୋଟେ ଇମ୍ପୋର୍ଟାଣ୍ଟ କଥା ଯୋଉ ଆପଣ ଯୋଉ କହିଲେ ଯେ advertisement in local newspaper ରେ କରିଦବା and defendant କୁ ସେଟା substituted service ହେଇଯିବ. ଯଦି ସେଠି accused ଲେଖିଛି ସେଠି defendant ଲେଖିବା କଥା accused ଭୁଲ ଲେଖିଛି. Defendant ଏଠି plea ନେଇପାରିବ କି that he does not read the newspaper? That was ଆପଣ ଏଇଟା ମତେ answer କରିବେ that whether accused can take a plea, I mean whether the defendant can take a plea that he does not read newspaper. Please answer it at the end of the session, not right now, and then we'll discuss it then as well. Now coming to the next rule which talks about that ଯଦି summons ଏବେ outside jurisdiction ରେ serve କରିବାର ଥିବ, suppose ଝାଡଖଣ୍ଡ ର ଗୋଟେ summons କୁ ଆପଣ serve କରିବାକୁ ଚାହୁଁଛନ୍ତି, ଝାଡଖଣ୍ଡ ର ଗୋଟେ district, then in that case how a summons will be served? It is said that ସେଇ case ରେ summons କେମିତି serve ହବ? That it will be sent through any court other than the high court. ଆପଣ ସେଇ ଝାଡଖଣ୍ଡ ର ସେ କୋଉ କୋର୍ଟ ଯୋଉଟା କି ଲୋକାଲ ଜୁରିସଡିକ୍ସନ ଥିବ ଯାହାର ସେଇ ଡିଫେଣ୍ଡେଣ୍ଟ ଯୋଉଠି ରହୁଛି ତା ଥ୍ରୁରେ ଆପଣ ସର୍ଭ କରିପାରିବେ. କୋଉ ୱେ ରେ କରିପାରିବେ? ଆଇଦର ଆପଣ ପ୍ରୋସେସ ସର୍ଭର ଥ୍ରୁରେ ସର୍ଭିଂ ଅଫିସର ଆପଏଣ୍ଟ କରି କରିପାରିବେ, ପୋଷ୍ଟ ରେ ପଠେଇ ପାରିବେ, ଅପ୍ରୁଭଡ କୋରିୟର ସର୍ଭିସ ରେ ପଠେଇ ପାରିବେ, ଫ୍ୟାକ୍ସ ରେ ପଠେଇ ପାରିବେ, ଇଲେକ୍ଟ୍ରୋନିକ ମେଲ ସର୍ଭିସ ରେ ପଠେଇ ପାରିବେ, ଅଦର ମିନ୍ସ ଆଜ ମେ ବି ପ୍ରୋଭାଇଡେଡ ସେଥିରେ ବି ପଠେଇ. ନେକ୍ସଟ ଇଜ ରୁଲ 22. ତାଦେହରେ କଣ କହିଲା ଆଉ ଗୋଟେ ଛୋଟ ରୁଲ ଟେ କହିଛି that କାଲକାଟା ମାଡ୍ରାସ ବମ୍ବେ ଯେହେତୁ ଆଗରୁ ସେମାନେ ସବୁ ପ୍ରେସିଡେନ୍ସିଆଲ କୋର୍ଟ ଥିଲେ, in that case ଯଦି କାଲକାଟା ମାଡ୍ରାସ ବମ୍ବେ ରେ କିଛି ସର୍ଭ କରିବାର ଥିବ ଆପଣଙ୍କ ସମନ ଆଉ ଆପଣ ବାହାରୁ କିଛି ସମନ ପଠାଉଛନ୍ତି ମାନେ ଅଲଗା କୋର୍ଟ ରୁ ଆପଣ କାଲକାଟା ମାଡ୍ରାସ ଆଉ ବମ୍ବେ ଭିତରେ ଜୁରିସଡିକ୍ସନ ରେ କୋର୍ଟ ଅଣ୍ଡର ରେ କିଛି ଡିଫେଣ୍ଡେଣ୍ଟ ରହୁଛନ୍ତି ତାକୁ ପଠାଇବାକୁ ଚାହୁଁଛନ୍ତି, then in that case you have to send it to the court of small causes. That is rule 22. Now coming to rule 23 which says that ଏଇ ସବୁ କୋର୍ଟ ଏଇ ଯୋଉ ଆଉଟସାଇଡ ରୁ ଆସିଲା କି ଆଉଟସାଇଡ କୁ ଆପଣ ଦେବାକୁ ଚାହିଁଛନ୍ତି କି କାଲକାଟା ବମ୍ବେ ମାଡ୍ରାସ କୁ ଦେବାକୁ ଚାହୁଁଛନ୍ତି ଯୋଉ ସ୍ମଲ କଜେସ୍ କୋର୍ଟ କୁ ଦେଲେ, court will treat it as its own summons and return with recording of proceeding. ସେଠୁ ଏଇ ଯୋଉ ଆପଣ ଝାଡଖଣ୍ଡ ରୁ ପଠେଇଥିଲେ କେମିତି ପଠେଇଥିଲେ ଯେ କୋର୍ଟ ଥ୍ରୁ ରେ କିମ୍ବା କାଲକାଟା ମାଡ୍ରାସ ବମ୍ବେ କୁ କେମିତି ପଠେଇଥିଲେ କୋର୍ଟ ଅଫ ସ୍ମଲ କଜେସ୍ ଥ୍ରୁ ରେ, then such court will treat the same as its own summon ଆଉ ତାକୁ ସେ ସର୍ଭ କରିବାକୁ ଟ୍ରାଏ କରିବ. ଯଦି ସର୍ଭ ନ କରିପାରୁଛି ତାହେଲେ reasons record କରିକି ତାକୁ send back. Whatever it is, you'll have to do. Rule 24. Rule 24 is saying that if the defendant is in prison, then it will be served on the officer in charge of the prison. So basically ଯଦି ଗୋଟେ defendant ଟା ଆଗରୁ jail ରେ ଅଛି, କଣ ଗୋଟେ murder murder କରିକି jail ରେ ଅଛି, ତାହେଲେ in that case how it will be served? ଆପଣ କହିବେ ଯେ ସେ କଣ jail ରୁ ବାହାରିଲେ ତାକୁ serve କରିବେ? ନା, ଆପଣ ଯାଇକି ଜେଲର କୁ ଦେବେ, ଜେଲର ଯିଏ ଚାର୍ଜ ଥିବ ତାକୁ ଆପଣ ଦେଇଦେବେ and it will be deemed as if ଆପଣ ସର୍ଭିସ କରିଛନ୍ତି. ସେ ଜେଲର ଡ୍ୟୁଟି ଏବେ ପଳେଇ ଆସିବ କି ସେ ତାକୁ ସର୍ଭ କରିବ. ଅଫକୋର୍ସ ଆପଣ କହିବେ ଯେ ଜେଲରକୁ ଦେଇଦେଲେ ତାମାନେ ସର୍ଭ ହେଇଗଲା, ସେଟା ମୁଁ କହୁନି, ୱିଲ୍ ଷ୍ଟଡି ଦ୍ୟାଟ ଜେଲରକୁ ଦେଲେ ସେ ସବୁ କେସରେ ଆପଣ କଣ. ତାପରେ 25 ରେ ହେଲା ଯଦି ଆପଣ ଆଉଟସାଇଡ ଇଣ୍ଡିଆ ପଠେଇବାକୁ ଚାହୁଁଛନ୍ତି ସବୁ ଏକ୍ସେପ୍ଟ ବାଂଲାଦେଶ ଆଉ ପାକିସ୍ତାନ, ଆପଣ ଆଉ କୋଉ କଣ୍ଟ୍ରି କୁ ପଠେଇବାକୁ ଚାହୁଁଛନ୍ତି, then it may be sent through post, any approved courier, EMS, fax or any other approved way. এই ସବୁକୁ ଆପଣ ଯଦି ପଠେଇବାକୁ ଚାହୁଁଛନ୍ତି ତାହେଲେ ଏଇ ସବୁ ଥ୍ରୁରେ ଆପଣ ପଠେଇ ପାରିବେ. ବଟ୍ ଇଫ୍ ଇଟ୍ ଇଜ ବାଂଲାଦେଶ ଆଣ୍ଡ ପାକିସ୍ତାନ, ଯଦି ବାଂଲାଦେଶ ଆଉ ପାକିସ୍ତାନକୁ ଆପଣ ପଠେଇବାକୁ ଚାହୁଁଛନ୍ତି, then in any area of that court ଯୋଉଟା ସେଇ କୋର୍ଟର ଏରିଆ ଯାହା ଉପରେ jurisdiction ଅଛି ସେ କୋର୍ଟର, through that court you can send, not except the high court. ଆପଣ ହାଇ କୋର୍ଟକୁ ଟ୍ରାଭେଲ କରିପାରିବେନି ଯେ ଏବେ ଯେ ଆପଣ ଏଠି ଜେଏମଏଫସି ହେଇକି ଗୋଟେ ସମନ ପଠେଇବେ ଯେ ହାଇ କୋର୍ଟ ଅଫ ବାଂଲାଦେଶ ମେ ସର୍ଭ ଦି ସମନ, नो यू कांट डू सच. ଆପଣ ଅଲଗା କୋଉ କୋର୍ଟକୁ समन पठेଇ ପାରିବେ that it may be served. ଆଉ ବାଂଲାଦେଶ ପାକିସ୍ତାନକୁ କାହିଁକି ଏଟା ଦିଆଯାଇଛି, because it was before partition ସେମାନେ ଆମର ପାର୍ଟ ହିଁ, ତ in that way ତାଙ୍କୁ ସ୍ପେଶାଲ ଷ୍ଟାଟସ ଦିଆଯାଇଛି. ସିଭିଲ ପ୍ରୋସିଜର କୋଡ 1908 ରେ ଆସିଲା and ତାପରେ ଆମେଣ୍ଡମେଣ୍ଟ ରେ ଏଟା ବାଂଲାଦେଶ ପାକିସ୍ତାନ କରାଯାଇଛି ଆପଣ ଯଦି ତାଙ୍କୁ ଦେବେ ତାହେଲେ କୋର୍ଟ ଥ୍ରୁରେ ଦେଇପାରିବେ। ଆଉ ଅଲଗା କୋଉଠି ଦେବାର ଥିଲେ ତାହେଲେ ପୋଷ୍ଟ କୋରିୟର ଇଏମଏସ୍ ଫ୍ୟାକ୍ସ ଆର୍ ୟୋର ଓନଲି ଗୋ ଟୁ ଅପସନ୍। ରୁଲ୍ 26 ରେ କହିଲା ଯଦି ଫରେନ୍ କଣ୍ଟ୍ରିରେ ଆପଣ ସର୍ଭ କରିବାକୁ ଚାହୁଁଛନ୍ତି ତାହେଲେ ପଲିଟିକାଲ ଏଜେଣ୍ଟ କିମ୍ବା କୋର୍ଟ ଏଷ୍ଟାବ୍ଲିଶ୍ଡ ଫର ଦ୍ୟାଟ୍ ପର୍ପସ୍ ଅର୍ ପୋଷ୍ଟ ଅର୍ ଅଦରୱାଇଜ ଆପଣଙ୍କୁ ତାମାନେ ଯଦି ଆପଣଙ୍କର ଆମ୍ବାସାଡର୍ସ ଅଛନ୍ତି ଏ ଯୋଉ ଆଇଏଫଏସ୍ ମାନେ ଆପଏଣ୍ଟ ହୁଅନ୍ତି ତାଙ୍କର ସେଠି ଥାନ୍ତି ଅଲଗା ଅଲଗା କଣ୍ଟ୍ରିଜରେ ୟୁ କ୍ୟାନ୍ ସର୍ଭ ଦି ସମନ୍ସ ଥ୍ରୁ ଦେମ୍ ଆଜ୍ ୱେଲ୍। ଆଉ ସେମାନେ ଯଦି ସେଠି ରିଟର୍ନ କରିଦେଲେ ଏଣ୍ଡୋର୍ସମେଣ୍ଟ କରିକି that it has been served duly then it will be deemed to be served and ସେମାନେ ଯଦି endorsement return କରିଦେଲେ na it has not served then it will be taken as the evidence that it was not served. Now comes the next rule which talks about summons to be sent to officers appointed by Ministry of Foreign Affairs. We have to see just know ki I'm discussing all the rules because I don't want you to miss out on any provision when facing with prelims questions. Actually, prelims it is getting very unpredictable and questions are asked from anywhere. So if you know all the rules in a nutshell, I think that will be more proper way to go about the examination rather than only touching the important aspects. So ଆପଣ ସବୁ rules କୁ ଯଦି ଥରେ ପଢିଥିବେ ଥରେ ଜାଣିଥିବେ this rule speaks about that. When you see the question you will remember it. ଆମକୁ ଆପଣଙ୍କୁ ମନେ ପଡିଯିବ ଯେ ଆରେ ଏଇଟା ତ ମୁଁ ପଢିଥିଲି। You are bound to human brain is such कि ଆପଣଙ୍କୁ ମନେ ପକେଇବ that this day maybe ପୁରା exact provision ଆପଣଙ୍କୁ ମନେ ନ ପଡେ କିଛି ତ ମନେ ପଡିବ। That is the reason best way to go about it is कि you have to go through each rule at least once and at least you have to understand the concepts. ଆପଣ concept ବୁଝନ୍ତୁ rule ମନେ ରଖନ୍ତୁ importance but ସବୁ ଯାକ ମନେ ରଖିବାକୁ ମୁଁ କହୁନି but ପଢନ୍ତୁ ସବୁ ମନେ ରଖନ୍ତୁ ଯୋଉଟା important ଆପଣଙ୍କୁ ଲାଗୁଛି you may remember them. Rule 27 ହଁ ଏଇ rule 26 ଏଇଟା କଣ କହିଲା that summons to be sent to officers appointed by MFA Ministry of Foreign Affairs ଯୋଉ officers କୁ appoint କରିଥିବ then summons may be sent to officers like that and ସେଇମାନେ ଯଦି endorsement କରିଦେବେ that sufficiently it has been served then it will be deemed as if it has been sufficiently served. Now coming to rule 27 which talks about service to public officer or railway employee. So ଆପଣ ଯଦି ଗୋଟେ public officer କିମ୍ବା railway employee କୁ ଆପଣ serve କରିବାକୁ ଚାହୁଁଛନ୍ତି then how will you serve? You will send through the head of the department. ଆପଣ HOD କୁ ଦେବେ ସେଠି summons ଟା HOD କୁ ଦେବେ. The head of the department ଯଦି କିଏ public officer ଅଛି ତାହେଲେ HOD କୁ ଦେବେ। railway ରେ ତାଙ୍କର ଯିଏ ଥିବ ଯିଏ head ଯିଏ ଥିବ ତାକୁ ଦେବେ। rule 22 ରେ କହିଲା ଯଦି ଆପଣ army naval କିମ୍ବା air force ର କୋଉ ଲୋକକୁ ଦେବାକୁ ଚାହୁଁଛନ୍ତି then you will give it to the commanding officer of that person. ସମସ୍ତଙ୍କର ସବୁ ଆର୍ମି ଗୋଟେ କମାଣ୍ଡିଂ ଅଫିସର ଥାନ୍ତି ତାଙ୍କୁ ଆପଣ ଦେବେ। ରୁଲ 29 ରେ କହିଲା ଏଇ ସବୁ ଯୋଉ ଆପଣ କମାଣ୍ଡିଂ ଅଫିସର କୁ ଦେଲେ ଏଚଓଡି କୁ ଦେଲେ ଏମଏଫଏ ରେ ବାହାରକୁ ଦେବାର ଥିଲା ତ ମିନିଷ୍ଟ୍ରି ଅଫ ଫରେନ୍ ଆଫେୟାର ଯୋଉ ଆମ୍ବାସଡର କୁ ଦେଲେ କି ପଲିଟିକାଲ ଏଜେଣ୍ଟ କୁ ଦେଲେ କିମ୍ବା ଏଠି ବାଂଲାଦେଶ ପାକିସ୍ତାନ ଗୋଟେ କୋର୍ଟ କୁ ଦେଲେ କିମ୍ବା ଏଠି ପ୍ରିଜନ ରେ ଆପଣ ଦେଲେ ଓଆଇସି ପ୍ରିଜନ କୁ ଦେଲେ all such officers to serve if possible and return with acknowledgement and sign of the person who is getting the summons. ଆପଣ ସେମାନେ କଣ କରିବେ ଟ୍ରାଏ କରିବେ ସମନ୍ ସର୍ଭ କରିବା ପାଇଁ ଯଦି ସମନ୍ ସର୍ଭ କରିଦଉଛନ୍ତି ତାହେଲେ ତାର ସେଠି ସାଇନ୍ ନେଇଯିବେ ଆଉ ଆକ୍ନୋଲେଜମେଣ୍ଟ ଲେଖିଦେବେ that ହଁ ସମନ୍ସ was served properly ଆଉ ଗୋଟେ କପି ଦେବି କି ଆପଣଙ୍କୁ ଆର କପିଟା ରିଟର୍ନ କରିଦେବେ ଯୋଉ ଅରିଜିନାଲଟା ରିଟର୍ନ କରିଦେବେ। So in that case you will know that summons was duly served. If impossible କିମ୍ବା ଯଦି ସର୍ଭ ନ କରିପାରୁଛନ୍ତି ତାହେଲେ ବି ଗୋଟେ ରିଜନ୍ସ ରେକର୍ଡ କରିକି that for this reason it could not be served ସେଇଟା ବି ଆପଣ ସେ ରେକର୍ଡ କରିକି ଦେବାକୁ ପଡିବ and in that will be taken as evidence of non service ଧରାଯିବ କି ସେଟା ସର୍ଭିସ ହେଇନି ବୋଲି that will be taken. Now comes rule 30 which says that instead of summons ଯଦି high ranked officials involved ଅଛନ୍ତି ପ୍ରେସିଡେଣ୍ଟ କୁ ଆପଣ ପ୍ରେସିଡେଣ୍ଟ କୁ ଛାଡ ମୁଁ ଅଭ୍ୟାସ କହୁଛି ସପୋଜ ଡେପୁଟି ସ୍ପିକର ଅଫ ଲୋକସଭାକୁ ଆପଣ ଡାକୁଛନ୍ତି or ଗୋଟେ ଜୁଡିସିଆଲ ମାଜିଷ୍ଟ୍ରେଟ କୁ ଡାକୁଛନ୍ତି or ଗୋଟେ ଏକ୍ଜିକ୍ୟୁଟିଭ ମାଜିଷ୍ଟ୍ରେଟ କୁ ଡାକୁଛନ୍ତି in that case instead of issuing a summons the court may issue letters ମାନେ ସେଠି ଆପଣ you are hereby directed to appear ଏମିତି କରିକି ଗୋଟେ କଲା ବେଳକୁ ଗୋଟେ it is like you are directing an authority. So instead of that you can write a letter. My respected sir, uh, you are hereby requested to appear on the date of date so and so at time so and so at the place so and so to uh, answer to the claim made by the plaintiff so and so in TS number dash. You can write a letter like that, and that will be the that will be treated as if it is a summons. But ତା ମାନେ ନୁହଁ ଯେ ଆପଣ ଲେଟର ଲେଖିବେ ମାନେ ତା ମାନେ ନୁହଁ ଯେ ରିଲେଭେଣ୍ଟ ଯୋଉଗୁଡା ମୁଁ କହିଥିଲି କଣ୍ଟେଣ୍ଟସ ଅଫ ସମନ୍ସ, ସେ ସମନ୍ସ ରେ କଣ ରଖିବେ ସେଇ ସମନ୍ସ ଗୁଡାକ ଆପଣ ତାର ଇଏ ଗୁଡାକ ମାନେ ଡେଟ୍, ପ୍ଲେସ୍, ଜଜ ର ସାଇନ୍, ସିଲ୍, କି କେତେବେଳେ ଆପିୟର କରିବ, ରିଜନ୍ସ କଣ ପାଇଁ ଡାକିଛନ୍ତି, ଏସବୁ ଗୁଡା ଆପଣ ନ ଲେଖିକି ଆପଣ ପଠେଇଦେବେ ଖାଲି ଲେଟର, ୟୁ କାଣ୍ଟ ସେଣ୍ଡ। ଇଟ୍ ଇଜ ନଟ୍ ଏ ମାନେ କିଛି ନର୍ମାଲ କନଭରସେସନ ଲେଟର ନାହିଁ। ତ ସେଇଟା ବି ଲେଟରଟା ଗଲେ ବି ଆପଣ ସେଟା ସମନ୍ସ ଭଳିଆ ଫର୍ମରେ ଯିବା ଦରକାର। You can send the same by post or by special messenger. So this completes our discussion on order 5. Now coming to the most important, most important because mostly in all the prelims questions I've seen, at least one question is asked from order. Sometimes in mains also it is asked. Order 9 re ସବୁବେଳେ question ଆସୁଛି. Let's just say कि you have to know this in and out. Concept is very not very complicated. Concept ଟା ବହୁତ simple. ଯେ parties କୁ ଆପଣ ଡାକିଲେ, ଯେତେବେଳେ ଆପଣ ଗୋଟେ plainଟା file ହେଲା, when a plaint is filed, suit is instituted. Now the court will call upon the party. If the parties do not appear, then what will be the consequence of such non-appearance? କୋର୍ଟ କୁ ତ ଆପଣ ସୁଟ୍ ଟା ନେଇ ଯାଇଥିଲେ, ଏବେ ଯଦି ପାର୍ଟି ନ ଆସିବେ କୋର୍ଟ କଣ ସେଠି ବସିକି ମାନେ ଫାଇଲ ଟାକୁ ଚଷୁଥିବ? What will be the remedy that is available to the court? Not the remedy, I'll say, what will be the power of the court to to act on that suit if the parties to the suit do not appear? That has been given in order 9. The parties no asile, then court ପାଖରେ କଣ action ନେବାର power ଅଛି ସେଇ ସବୁ order 9 ରେ ରହିଛି. So before going to the rules, let me just tell you that briefly non appearance ତିନିଟା type ର ହେଇପାରେ. First ହଉଛି non appearance କେମିତି ହେଇପାରେ? Plaintiff ଯିଏ file କରିଛି ସିଏ ଆସିବ. That is one kind of non appearance. Second is defendant ଯାହାକୁ ଡକା ହେଲା answer କରିବା ପାଇଁ claim ସିଏ ଆସିଲାନି, ସେଇଟା ହଉଛି ଗୋଟେ non appearance. ଆଉ ଗୋଟେ type ର non appearance ହଉଛି ଦି ପାର୍ଟି ଆସୁଛନ୍ତି. So basically order 9 is dealing with, in a nutshell, it is dealing with three types of non-appearance, what will be the consequence of such non-appearance, and what will be the remedies available if any action has been taken by the court because you were not appearing in the court when you were called for. So basically ଏଇ ତିନିଟା ଜିନିଷ, ତାର action, ତାର remedy, this is what it deals with. First ଭାବୁଛି ଆମେ ତାପରେ ଆମେ ପଢିବା, ମୁଁ ତାପରେ ସବୁ ରୁଲ ଡିସ୍କସ କଲା ପରେ I'll tell you how to remember it, କି କେମିତି ଆପଣ ମନେ ରଖିବେ। ଯେମିତି ଡିଭାଇଡ କରିକି ବତେଇଲି ଯେ ବୋଥ ପାର୍ଟିଜ, वन ପାର୍ଟି ପ୍ଲେଣ୍ଟିଫ, वन ପାର୍ଟି ଡିଫେଣ୍ଡେଣ୍ଟ, ତିନିଟାକୁ ଆପଣ ଡିଭାଇଡ କରିବେ। ତିନିଟାରେ ଆପଣ ମନେ ରଖିବେ ତିନିଟା ଜିନିଷ, ଯେ ଯଦି ସେମାନେ ଆପିୟର ନ କରନ୍ତି କଣ ଆକ୍ସନ ନେଇ ହେବ, ସେମିତି ଯଦି ଆକ୍ସନ ନିଆ ହେଲା ତାର ରିମେଡି କଣ, ସେମିତି ଆରଟାରେ ବି ସେୟା, ଆରଟାରେ ବି ସେୟା। ତିନିଟା করে ଆପଣ if you remember this much, I think your order 9 will be complete. Let's just proceed with the rules first. At the end, probably I will not be able to finish all the rules today. I will discuss up to rule 9, take up the next rules tomorrow, and then in a nutshell, I'll tell you how to remember the order 9. I'll divert another extra class to order 9 because I feel it is very important. At least you'll get somehow, if you get 1-2 questions from uh, uh, in the prelims, and if you get one or half question in the mains, at least 5-6 marks I see from order 9. Order 9. So that's why I must say that you have to pay extra attention. जे rule 1 रे कौन कहला, that rule 1 रे simply कहूची जेतबे court fix करूची day hearing रो, ସେତେବେଳେ ଆଉ parties କୁ ଡକା ହେଇଛି ଯେ appear କରିବା ପାଇଁ, the parties have to appear either in person or by pleader. ଆମେ ପଢିଥିଲେ ଯେ କେମିତି appear କରିପାରିବେ, in person appear କରିପାରିବ, through a pleader କରିପାରିବ uh, who is duly appointed to answer all the questions, or by a pleader and accompanied with another person duly authorized to answer, I mean duly knowing all the answers to the important questions that can be put. So in that case ସେମିତି appear କରିପାରିବ ବୋଲି କହିଲେ। ତ ଏବେ କହିଲା rule 1 ରେ କହିଲା ଯଦି parties କୁ ଡକା ହେଇଛି appear କରିବା ପାଇଁ court ରେ on the date fixed for hearing, then they have to appear either in person or by pleader. ଏଇ ଯୋଉ appear କରିବା ପାଇଁ ଡକା ଯାଏ, that is called first hearing. first hearing ta first pore tapare eta adjourn hue, then it is called hearing. So how it is basic rule is that suit can't proceed without a party being present. So basically we all know that principle of natural justice says that no one should be condemned unheard. So basically when you are proceeding with a suit, both parties must be present. We are not saying when they have to be present doesn't mean that they have to be physically present or they have to be personally present. They can appear through pleader, but they must be represented. The word would be that the suit cannot proceed without their representation, not without them. The suit cannot proceed without they being represented. That is one rule. One says that when the parties will be directed to appear in the court on the day fixed for the hearing, they will have to appear either in person or by pleader. Of course, if the court adjourns the same to a future day, then they may not appear that on that day and then again appear on the next day. Rule 2 says if summons could not be served to the defendant due to the plaintiff's fault and the defendant could not be present. So this is basically again in a case where the defendant is not appearing. We have discussed three modes, three instances. The first hoji both parties are not appearing, defendant is not appearing, plaintiff is not appearing. Here this talks about defendant not appearing. So the defendant it he appear karuni, and the that is why because the plaintiff due to the plaintiff's fault, the defendant could not be present. Uh, and why? Because summons could not be served to the defendant. The defendant asiparlani. Why? Because the summons could not be uh, served to the defendant. And why was that done? Due to the plaintiff's fault. Then in that case, suit will be dismissed. The plaintiff ର ଭୁଲ ପାଇଁ summons serve ହେଲାନି ତାହେଲେ କଣ ହବ ଏଠି plaintiff ର suitଟାକୁ dismiss କରିଦବା କାହିଁକିନା ତୁ ତ ଦେଇଥାନ୍ତୁ ଏଠି କୋର୍ଟ ଫିସ୍ ଦେବାର ଥିଲା या ପ୍ରୋସେସ ଫିସ୍ ଦେବାର ଥିଲା କିମ୍ବା ଯଦି ଆମେ ପଢିଥିଲେ ଯେ ପ୍ଲେଣ୍ଟ ର କପି ଦବ ଏଥିରେ ପଢିଥିଲେ ସମନ୍ସ ରେ ବି ଯାଉଛି ପ୍ଲେଣ୍ଟ ର କପି ସମନ୍ସ ସହିତ ଗୋଟେ ପ୍ଲେଣ୍ଟ ର କପି ଆଉ order 7 ରେ specifically rule 9 ରେ ବି କୁହାଯାଇଥିଲା ଯେ ପ୍ଲେଣ୍ଟ ର କପି ଦିଆହବ. So in that case it says if due to plaintiff's fault the summons could not be served on the defendant and the defendant could not be present, then the suit will be dismissed. If the defendant is present even though the summons was not served, what will be the fate? এই কেসরে summons serve ହେଇନି କିନ୍ତୁ defendant ନିଜେ ନିଜେ ପଳେଇ ଆସିଛି ଶୁଣିକି କୋଉଠୁ ଯେ ନାଇଁ ନାଇଁ କେସଟା ତ ହେଇଛି summons ହେଇଥାଉ ନ ହେଇଥାଉ ସେ ଡରିକି ତାର ପଳେଇ ଆସିଛି ସେ ଜାଣିନି ଏ ରୁଲ ବିଷୟରେ ଯେ ସୁଟଟା ଡିସମିସ୍ ହେଇଯିବ ସେ innocently ପଳେଇ ଆସିଲା. Then in that case should be dismissed? The answer is no. Defendant, the prerequisite of this rule is that the defendant should not be present and defendant could not be present. Why? Because summons could not be served. And why that summons could not be served? Due to the fault of the plaintiff. And how that fault was committed? By non-payment of court fees, non-payment of process fees. That is process fees माने जो एई समन रो जहा पे फीस दरकार समन टा सपोज पोस्ट रे पठार अछि स्पेशल मैसेंजर रे पठार अछि स्पीड पोस्ट रे पठार अछि जहा भी अछि तार प्रोसेस फीस देले or copy of plaint not given to the not given as asked by the order 7 rule 9, and in that case the suit will be dismissed. And it is the suit ta dismiss hoji appeal kichi nahi, revision of course it can be done, but if the plaintiff's fault ପାଇଁ summons serve ହେଇ ପାରୁନି and defendant asuni, then in that case suit will be dismissed. Next is rule 3 which says if neither party appear, ଆମେ କହିଥାଇଥିଲେ that both the parties if they do not appear, that is one non appearance. If both the parties do not appear, then the suit may be dismissed. କେହି ତ ଆସୁନାହାନ୍ତି କୋର୍ଟ କଣ ବସିକି କେସଟାରେ ସୁଟ୍ ଟା ଧରି କଣ ତା ଘରର କେସ୍ ନା କଣ କୋର୍ଟର ଘର ତ ନୁହଁ ତ ସେ ତ ତାକୁ ପାର୍ଟିଜ ଆସିକି ତାକୁ ପର୍ସୁ କରିବାକୁ ପଡିବ. କୋର୍ଟ କ୍ୟାନ୍ ନଟ୍ ଆକର୍ଡିଂ ଟୁ ଇଟ୍ସ ଓନ୍ ଆକର୍ଡ ତାର ପ୍ରୋସିଡ୍ କରିପାରିବନି ମନ ଇଚ୍ଛା. ତ ଆମକୁ ଯାହା ହେଲେ ଡୋମିନସ୍ ଲିଟିଗେସନ ଆମେ ପଢିଥିଲେ that plaintiff is the master of the suit, plaintiff has to be present and someone has to defend it who is known as the defendant. If both the parties are not present, this suit will be dismissed. That will be the ultimate fate. Rule ସେଥିରେ କିନ୍ତୁ ଏବେ ତାର ତାର ଆମେ ଏଠୁ ଆମେ ଦେଖିବା ଯଦି both the parties ନ ଆସୁଛନ୍ତି, then what will be the fate, that what will be the remedy available ଯଦି suit ଟା dismiss ହେଇଗଲା because both the parties did not appear, then in that case कौन हे परिबो सेटा कहूची रूल 4 रे दैट फर्स्ट रे हमरो जदी सुटा डिसमिस हेची रूल 2 रे किंबा रूल 3 रे डिसमिस हला रूल 2 रे कम पे डिसमिस हला काइना समन सर्व हेई पल्लानी और डिफेंडेंट आसिला आउ रूल 3 रे जदी नाइदर पार्टी आसिले ताले एठी जदी ताले एठी कोन रिमेडीज अछि कहला that the plaintiff may bring fresh suit on the basis of same cause of action. So basically, plaintiff has this remedy that he can bring a fresh suit altogether. Of course, limitation period थिबा दरकार. Limitation law रे expire कर जाइथिबो आपण fresh suit आनिबे कहबे नाही बे. But if the limitation period भितर अछि, then in that case, on the basis of same cause of action, the plaintiff may bring a fresh suit. आ ଗୋଟେ नुवा suit एकाथरे फाइल कर आउ कोन कर परिबो that set aside the dismissal order by providing sufficient cause. ଏହା ବି କରିପାରିବ that ସେ ଯୋଉ dismiss ହେଲା rule 2 କିମ୍ବା rule 3 ରେ ତାକୁ set aside କରିବା ପାଇଁ sufficient cause ଦେଇକି କୋର୍ଟ କୁ satisfy ଯଦି କରିଦେଲା that ଏଇ ଯୋଉ ମୁଁ payment of court fees ଦେଇନଥିଲି କାହିଁକି ନା ମୁଁ properly ମୋର ମତେ ଜଣା ନଥିଲା ଯୋଉ ମତେ ଦେଇନଥିଲା ଆପଣଙ୍କର ସେରିସ୍ତେଦାର properly office note କରିକି or process fees ଟା non payment was because he was suffering from covid or plaint could not be given for some reason so the copy of the plaint could not be given for some reason if if the plaintiff can satisfy that then in that case or जो neither party appear सही केस रे डिसमिस हेतला सेठी plaintiff को कला ना कोन करियो ना कहबो जे नाइ नाइ मु एथि पे आस्पलिनी बिकॉज़ मोर एया हला मु आई वाज इल पर्सनली देखा हेतला बट मु कोविड रे पड़ी गेली तो मु आस्पलिनी in that case the sufficient answer there hoji then such dismissal order that was done in rule 2 and rule 3 they can be set aside we'll have to remember that as this is dismissal on default hence no res judicata lies so basically एठी default रे dismiss जतु होची एठी res judicata like on एठी भी हम आउट typical जिंस order 9 रे will have to know that order 9 रे in some cases there is a provision to file a fresh suit in some cases there are no provision to bring a fresh तो सेटा को हमको मन रखिया पड़िबो कोथरे फ्रेश शूट करिवे कोथरे फ्रेश शूट कर परिवे इन द क्वेश्चन एस परे that in which of the cases the plaintiff is entitled to file a fresh suit on the basis of same cause of action subject to the law of limitation ସେଥିରେ ଚାରଟା ऑप्शन ଦେଇଥିବ ଆପଣଙ୍କୁ ଚूज କରିବାକୁ ପଡିବ କୋ କୋ ଇଏ ରେ plaintiff same cause of action ରେ ଗୋଟେ fresh suit ଆଣି rule 5 now coming to rule 5 rule 5 is talking about the fact that when summons unserved against defendant or one or more of the defendants ଯଦି ଗୋଟେ defendant ଅଛି ତାହେଲେ ତା against ରେ ଯଦି ଅଧିକା defendant ଅଛନ୍ତି ତାହେଲେ ଜଣଙ୍କ କିମ୍ବା ତାଠୁ ଅଧିକା ଲୋକଙ୍କ ଅଧିକା defendant against ରେ summons ଟା serve ହେଇ ପାରିଲା then in that case plaintiff ର duty କଣ that 7 ଦିନ ଭିତରେ ସେ fresh summon ପାଇଁ apply କରିବ that is plaintiff's duty that if someone could not be served against the defendant or one of the more defendants जो जेतले summons ଗୋଟେ issue करथिबो ମାନେ आपण ଦେଇथिबो कोर्ट issue करी देला वो summons टा गला for some reason it could not be served कोन पे सर्व होई पल्लानी मे बी इट वाज एड्रेस टा भूल थिला और कोन रे थिला जहां भी थिला so in that case the plaintiff's duty to apply for issue of fresh summons within 7 days but जदी plaintiff एटी alter करूची आउ if he is required to apply for issue of fresh summons within 7 days and he is failing to do that then the consequences of inaction would be that the suit shall be dismissed against such defendant so the suit will be dismissed against such defendant जदी गोटे defendant अछि ताले entire suit dismiss हे if more than one defendant अछंती आ जणको against serve हेनी and the defendant ता against 7 दिन भितर देलानी ताले जो against जहा against serve हेची ता against suit चलिबो बट जो defendant against रे serve हे पल्लानी आ 7 दिन भितर plaintiff देलानी भी against that defendant the suit shall be dismissed of course ये जो 7 दिन टा that can be extended if the plaintiff shows कौन शो करिवो plaintiff एठी जदी टाइम टा को एक्सटेंड करिया चाहूची से 7 दिन टा that से ड्यू डिलिजेंस रे भी plaintiff defendant रा घर खोज पल्ला ड्यू डिलिजेंस रे भी plaintiff रा घर खोज पल्ला second is defendant willfully summons को अवॉइड करूची तार किछि भूल नै डिफेंडेंट ही अवॉइड करूची summons सर्व करिया पे और other sufficient cause ମୁଁ ଯାହା କହିଲି କୋଭିଡ ହେଲା କଣ ହେଲା କି ତାର some assigning good reason is showing that why it could not be served, then in that case he is very well under law that the court will allow him further time uh, other than 7 days 7 दिन ପରେ ବି ଅଧିକା time ଦେଇହବ ଯଦି ସେ prove କରିଦବ why he couldn't give and say uh, he couldn't find the residence of the defendant even after due diligence. Defendant is avoiding service of summons and other sufficient cause for non provision of the uh, application to issue of fresh summons. Now coming to rule 6. Rule 6 is talking about the another case where plaintiff is appearing and the defendant is not appearing. If here it is saying that if the again ଆମେ ପଢିଥିଲେ ତିନିଟା case ରେ plaintiff non appearance, defendant non appearance, both parties non appearance. ଏଠି ଆଉ ଗୋଟେ case ରେ କୋଉଠି ଯୋଉଠି defendant appear କରୁନି. କଣ ପାଇଁ defendant appear କରୁନି সেটা কହୁନି କଣ ପାଇଁ appear କରୁନି ସେ କହୁଛି ଯଦି defendant appear କରୁନି ଆଉ plaintiff only appear କରୁଛି in that case ତିନିଟା ଜିନିଷ possible. First ହଉଛି ଯଦି summons duly serve ହେଇଥିବ what can be done if summons duly serve ନ ହେଇଥିବ ତାହେଲେ କଣ ହବ ଆଉ ଯଦି summons serve ହେଇଥିବ କିନ୍ତୁ ଠିକ time ରେ ହେଇନଥିବ then କଣ then what will be? So what it says that if the plaintiff appears and defendant does not appear and summons is duly served, then the court can proceed ex parte against the defendant. So ଯଦି summons ଟା ଠିକ ରେ serve ହେଇଯାଇଛି ଆଉ defendant still ଆସୁନି then in that case ଏଠି plaintiff ର କିଛି ଭୁଲ ନାହିଁ ତୁମକୁ ତ summons ଦିଆହେଲା କୁହାହେଲା କି suit ଟା ତମ against ରେ ହେଇଛି ତମେ ଆସିକି answer କର. It is your duty to come to the court and answer such claim, but you still avoided purposefully. In that case, the court can proceed ex parte. Second is if it is not duly served, then fresh summons can be issued. କହିଲା ଯଦି duly served ହେଇନି then what will be the fate? If it is not duly served, then fresh summons can be issued. Court will direct that ଆଉ ଗୋଟେ second summon ତାକୁ କର କାହିଁକି ନା summon ଟା issue ହେଇପାରିଲାନି summon ଟା serve ହେଇପାରିଲା. Third case ରେ serve ହେଇଛି କିନ୍ତୁ due time ରେ serve ହେଇନି. ଏଠି କଣ ହବ common sense will apply here that serve ତ ହେଇଛି but ତାକୁ ଏତେ time ଦିଆ ହେଇପାରିଲାନି suppose 500 ମାଇଲ ଦୂରରେ ରହୁଛି ତାକୁ କାଲି serve ହେଲା କାଲି serve ହେଲେ ସେ କଣ ଆଜି ଉଡିକି ଆସିକି ପହଞ୍ଚିବ in that case court will can grant a further time grant ଦେଇପାରିବ that date ଟାକୁ postpone କରି କହିପାରିବ future date ରେ ତମେ appear କର. So in this case ତିନିଟା କଥା ହଉଛି ଯଦି defendant appear କରୁନି ଆଉ summons ଟା duly serve ହେଇଛି କଣ ହବ that ex parte proceed କରିପାରିବ court. Ex parte ମାନେ without hearing the other party. That is called ex parte. That means normal rule is demands that both parties should be present or both parties should be represented as I told you and then only the suit will be heard. But ଏଠି defendant କୁ ଆପଣ ଡାକିଲେ ଯେ ଆସ ତମ ଯୋଉ କୁହନ୍ତି ଯେ ମା ସବୁବେଳେ ମତେ ଡାକିକି ମତେ ବସିକି ଖୁଆଇବେ ମୁଁ ମତେ ବହୁତ ଡାକିଲେ ମୁଁ ବସିକି ଆସିଲି ତାହେଲେ କହ ନା ଯା ଶୋଇପଡ ମୁଁ ବାକି ସମସ୍ତେ ଖାଇବେ ତୁ ନ ଖା. So similarly ଆପଣ ଯଦି ଆପଣ defendant କୁ ଡକା ହଉଛି ତୁ ଆସେ address କର ତୋର ଯୋଉ claim ଟାକୁ ଏବେ plaintiff file କରିଛି you have to address that claim. Defendant ଆସୁନି ତ ଏଠି court ବସିକି କଣ ଅପେକ୍ଷା କରିଥିବ forever? You can't do that. So here ଏଠି ସେ ex parte proceed କରିଥିବ that the defendant ନଥାଉ ତାକୁ ନ ଶୁଣିକି ଆମେ ଯିବା କାରଣ ତାକୁ opportunity ମିଳିଥିଲା and he still did not come. That means he does not want to come. It will be presumed that he does not want to come and he has no answer and it will be heard ex parte. ତାକୁ ex parte କରିକି proceed କରିକି ଯିବା ଆଉ plaintiff କାମ here ex parte concept ଟା ଆହୁରି ବି ଆମେ ପରେ ପଢିବା ex parte ଯେତେବେଳେ ଆମେ injunction ପଢିବା ଏସବୁ ପଢିବା ex parte concept ପଢିବା ex parte ଆପଣ ଏତିକି ଜାଣିଥାନ୍ତୁ that without hearing the other party you will proceed. Second is ଯଦି duly serve ହେଇଗଲା ତାହେଲେ duly serve ହେଇନି ତାହେଲେ ଆପଣ fresh summons କରିବେ but ଯଦି time ରେ serve ହେଇନି ତାହେଲେ date ଟାକୁ postpone କରିବେ. But ହଁ ଏଟା ବି ଜାଣିଥାନ୍ତୁ ଯଦି not duly serve ଯୋଉ second case ରେ not duly serve or if not served in due time ଯୋଉ third case ରେ serve ହେଇଛି କିନ୍ତୁ due time ରେ serve ହେଇନି then in that case if these two are due to the fault of the plaintiff then cost can be imposed on the plaintiff. ଏ ଯୋଉ fresh summons issue ହଉଛି ତାର cost ବି ଦବ କିମ୍ବା ଯଦି ଯୋଉ ଡେଟ୍ ଟା postpone ହେଲା ଥରେ ଯୋଉ ଆସିଥିଲେ କିଛି ୱିଟନେସ୍ ଆସିଥିଲେ or କେହି ଲୋକ ଆସିଥିଲେ ଯାହାକୁ ଆଉ ଥରେ ଡାକିବାକୁ ପଡୁଛି तो तांको पे जो खर्चटा कि जहां भी खर्चटा कॉस्ट आपनको दबाव पड़े। दिस इज व्हाट रूल 6 इज। रूल 7 रे कहला एक्सपर्ट जदि थरे हे गला ताहाले व्हाट इज द रेमेडी। एक्सपर्ट माने जदि तमे डिफेंडेंट आसिलानी आउ समन्स टा सर्व हेतिला किंतु डिफेंडेंट आसिलानी रूल 6 रे जो फर्स्ट पार्ट रे पढले रूल 6 रे फर्स्ट पार्ट रे पढले ना तो समन्स टा सर्व हेची किंतु स्टिल डिफेंडेंट आसिलानी ताले कोर्ट कोन कला ना एक्सपर्ट प्रोसीड कला एई से रूल 6 रे फर्स्ट पार्ट रे जदि एक्सपर्ट हियरिंग चलीची माने एक्सपर्ट करा है कि एबे प्लेंटिफ को खाली सुना जाउची इन दैट केस हियरिंग चलला बेले डिफेंडेंट आसिला डिफेंडेंट आसी कहला कि एई रीजन पे मु आस कली हां ठीक अछि तुम जो पूछो समन सर्व हो कथा समन मु पर सर्व हेतिला किंतु दिस इज द रीजन आई कुडंट कम then in that case he may be heard as if he had appeared on the previous days and such ex parte order जो order टा हेतिबो making him ex parte that will be set aside. Rule 7 रे कहला that setting aside an ex parte order can be done if the defendant is assigning a good reason why he was set ex parte, why he couldn't appear, and this is the reason he was set ex parte, and hence that set ex parte order may be set aside and he may be allowed to be heard as if he had appeared on the previous days. धरा जीव that से previous days रे appear करथिला और केम जेंति ex parte order किछि नथिला सेही भलिया ही proceed. Now coming to rule 8 which talks about when defendant only appears. एठी फर्स्ट हम पढुथिले जे डिफेंडेंट अपियर करूनी कोन होउची आ तापर पढले बोथ पार्टीज अपियर करनी कोन होउची एठी कहला डिफेंडेंट अपियर करची किंतु प्लेंटिफ अपियर कर रूल 8 रो सेडा कथा होला रूल 8 टू 11 पर्यंत इनफैक्ट होउची जेतले डिफेंडेंट अपियर करची किंतु प्लेंटिफ अपियर तो रूल 8 रे कहला इफ द प्लेंटिफ डज नॉट अपियर देन अगेन तीनटा जिंस हो जदि प्लेंटिफ अपियर करूनी आ डिफेंडेंट अपियर करिची फर्स्ट हियरिंग रे जेतले हियरिंग पई डकाइची आ प्लेंटिफ इज नॉट अपियरिंग बट द डिफेंडेंट इज अपियरिंग then एठी अगेन थ्री कोर्सेस फर्स्ट होउची द डिफेंडेंट क्लेम टाको एडमिट कर दोउची देन डिक्री कैन बी पास्ड जदि जहा क्लेम थिला प्लेंटिफ कोची जे मते मते डिक्लेयर करा जाऊ मोर पोजीशन टाको डिफेंडेंट आसी कोची हो ठीक अछि डिक्लेयर कर दियो दैट केस जदि डिक्लेयर कर दोउची तले ऑर्डर 12 रे हमर पढिबा तार एडमिशन को नै कि हमें डिग्री पास करि परिया तापरे जदि एडमिट करूनी क्लेम ताहले कोन हबो सूट टा डिसमिस हो जदि डिफेंडेंट एटी एडमिट करनी क्लेम ताहले सूट टा डिसमिस हो थर्ड इज डिफेंडेंट इज एडमिटिंग ए पार्ट ऑफ द if the defendant is admitting a part of the claim and not admitting the other part then in that case decree in respect of the admitted claim and the rest of the part that will be dismissed basically जदि प्लेंटिफ आसिलानी ताहले कोन हला तू तो मास्टर ऑफ द सूट यू हैड टू ब्रिंग योर केस बट राइट नाउ यू आर नॉट अपीयरिंग एबे स्टिल डिफेंडेंट दया करी जदि किछि पार्ट टाको एडमिट करि दोउची जदि पूरा एडमिट करूची ताले एडमिशन बेस रे डिक्री हेजी जदि किछि एडमिट करूची ताले सेई जो एडमिटेड पार्ट टा अगेंस्ट डिक्री हेबो बाकी पार्ट टाको डिसमिस कराबो बाकी अगेंस्ट किंबा जदि एडमिट टोटली करूनी देन द सूट विल एंटायरली बी डिसमिस्ड बट एई तापरे एबे कहला जदि प्लेंटिफ जो आसलानी ता पई डिसमिस हे गला तार रेमेडी टा देला रूल 9 रे देला जदि आपण डिसमिस କରି देले आउ the plaintiff was actually not appearing and you dismissed the suit, then what will be the remedy available to the plaintiff? That has been given under Rule 9. Rule 9 says that plaintiff may apply for restoration of the suit by assigning sufficient cause. So sufficient cause किंबा sufficient reason देगी plaintiff कौन कर परिवो apply कर परिवो restoration of the suit. एठी से फ्रेश शूट करि परियो आपन पढते जेतला हम पढुतले रूल 2 रूल 3 रे डिसमिस हेतला रूल 4 रे कोन कहितला दैट यू आर हियर इवन अलाउड टू फाइल ए फ्रेश शूट बिकॉज़ दैट वाज डिसमिसल फॉर डिफॉल्ट एंड आपन सेम कॉज ऑफ एक्शन रे गोटे फ्रेश शूट भी कर परथले आ ताको आपन सेटिस्फाइड भी कर परथले बट हियर यू कांट गो फॉर ए फ्रेश शूट आपन सेठी फ्रेश शूट कर परिबे एठी ओनली रिस्टोरेशन पई आपन अप्लाई करि परिबे दैट जो आपन डिसमिस कर देखले please restore that. So this is what the remedy that is available to the plaintiff that he may apply for restoration of the suit by assigning sufficient cause and it can be done within 30 days. Rule 10 and onwards, I couldn't get much time, so I couldn't prepare the slides. So I could teach you, but then I still think there is a lot that has been taught today, and you must uh, claim this, claim all of this in your memory, and then we'll proceed to the other rules. And the most important, order 9, rule 13, that will be discussed tomorrow, along with the revision thereof. ଯାହା ଯେ ପଢିଲେ ତାକୁ ବି ଆମେ ବସିକି ଏକାଥରେ ରିଭିଜନ କରିକି ଯୋଉ ପାର୍ଟରେ ଆପଣଙ୍କୁ ବୁଝେଇଲି ଦ୍ୟାଟ ତିନିଟା ଜିନିଷ ଆପଣଙ୍କୁ ମନେ ରଖିବାର ଅଛି। ଫର୍ଷ୍ଟ ହଉଛି ବୋଥ ପାର୍ଟି ନନ୍ ଆପିୟରାନ୍ସ, ସେଠି କଣ ହବ, କୋର୍ଟ କଣ କରିବ, ଆଉ ଯଦି କୋର୍ଟ କିଛି ଆକ୍ସନ ନେଲା ତାହେଲେ ଆପଣଙ୍କ ରେମେଡି କଣ। ତାପରେ ଆମେ ଆଉ ଗୋଟେ ରହୁଛି ଯେତେବେଳେ ପ୍ଲେଣ୍ଟିଫ ଆସିବ କିନ୍ତୁ ଡିଫେଣ୍ଡାଣ୍ଟ ଆସିବନି, ଦେନ୍ ଇନ୍ ଦ୍ୟାଟ କେସ୍ ଯଦି କୋର୍ଟ କଣ କରିପାରିବ, ଆଉ ତାହେଲେ ଡିଫେଣ୍ଡାଣ୍ଟ ପାଇଁ ଏଗେନଷ୍ଟ ଯୋଉ ଅର୍ଡରଟା ପାସ୍ ହେଇଥିଲା ଡିଫେଣ୍ଡାଣ୍ଟ ପାଖରେ କଣ କୋର୍ସ ଆଭେଲେବଲ ଅଛି। ତାପରେ ହଉଛି ଯୋଉ ତାକୁ ଆମେ ଏକ୍ସପେକ୍ଟ କରିଥିଲେ ତାର ଏଗେନଷ୍ଟରେ କଣ କରିପାରିବ। ଥର୍ଡ ଇଜ ଯଦି ପ୍ଲେଣ୍ଟିଫ ଆସିଲାନି ଆଉ ସୁଟଟା ଡିସମିସ୍ ହେଇଯାଇଛି, ଦେନ୍ what will be the course available to the plaintiff for his non appearance ରେ ଯୋଉ ସୁଟଟା ଡିସମିସ୍ ହେଇଛି। all these three ଆମେ ତାକୁ ଖାଲି ଗୋଟେ ରାଉଣ୍ଡ ଅପ୍ କରିକି will complete the discussion on order 9. So basically this was all about order 9 up to rule 9, I believe. If anyone has any doubt, they may put it right away. See, most of the times people tend to make it very complicated. Order 9 ମତେ ବହୁତ ଜଣ ଛୁଆ କୁହନ୍ତି order 9 is very difficult. I believe it is not. It is basically ତିନିଟା ହିଁ ଜିନିଷ କହୁଛି। ଗୋଟେ କହୁଛି both parties non appearance କଣ ହୋଇପାରି କଣ କରିପାରିବ କୋର୍ଟ, ତା ଏଗେନଷ୍ଟ ରେମେଡି କଣ। ପ୍ଲେଣ୍ଟିଫ ଆସିଲାନି, କୋର୍ଟ କଣ କରିପାରିବ, ତା ଏଗେନଷ୍ଟ ରେମେଡି କଣ। ଡିଫେଣ୍ଡାଣ୍ଟ ଆସିଲାନି, କୋର୍ଟ କଣ କରିପାରିବ, ତା ଏଗେନଷ୍ଟ ରେମେଡି କଣ। ଏଇ ତିନିଟା ତ ଜିନିଷ ହିଁ କହୁଛି। We discussed till rule 9. Rule 9 ପର୍ଯ୍ୟନ୍ତ ଯାହାର କିଛି ଡାଉଟ୍ ଅଛି you may ask. Otherwise କାଲି ଆମେ finish କଲା ପରେ you may ask as well.
ସାର୍ ନମସ୍କାର।
ନମସ୍କାର ନିତିଶ।
ସାର୍ ରୁଲ୍ 2ରେ ଯେଉଁଟା ଅଛି ଡିସମିସାଲ ଅଫ୍ ସୁଟ୍ ହେୟାର ସମନ୍ସ ନଟ୍ ସର୍ଭଡ୍ ଇନ୍ କନସିକ୍ୱେନ୍ସ ଅଫ୍ ପ୍ଲେଣ୍ଟିଭ୍ସ ଫେଲିୟର ଟୁ ପେ କଷ୍ଟସ୍, ଟିକେ ସାର୍ ବେୟାରଟା ଦେଖିବେ।
ଡାଇରେକ୍ଟ ଦେଖୁଛି କୁହନ୍ତୁ।
ସାର୍ ସେଥିରେ ଯେଉଁ ତାର ସେକେଣ୍ଡ ପାର୍ଟ ଅଛି ପ୍ରୋଭାଇଡେଡ୍ ଦ୍ୟାଟ୍ ନୋ ସଚ୍ ଅର୍ଡର ସାଲ୍ ବି ମେଡ୍ if not withstanding such failure the defendant attends in person or by agent when he is allowed to appear by agent on the day fixed for him to appear and answer। ସାର୍ ବୁଝିପାରିଲିନି ସାର୍ ଏକ୍ଜାକ୍ଟଲି ସାର୍। ସାର୍ ଫାଷ୍ଟ ପାରା ସାଙ୍ଗରେ ୟାର
Provided that no such order shall be made, if notwithstanding such failure, the defendant attends in person by agent. ମୁଁ ଆପଣଙ୍କୁ କଣ କହିଥିଲି ଯେ ମୁଁ ଆପଣଙ୍କୁ ସେଇଠି ଲେଖିଥିଲି ଯେ very very ମାନେ intelligently the legislature has formulated this rule। ମୁଁ ଆପଣଙ୍କୁ କହିଥିଲି that summons serve ହେଇପାରିଲାନି ଏଠି କଣ ପାଇଁ, ପ୍ଲେଣ୍ଟିଫର ଫଲ୍ଟ ପାଇଁ। ପ୍ଲେଣ୍ଟିଫର ଫଲ୍ଟ ପାଇଁ ସର୍ଭ
yes
ହେଇପାରିଲାନି,
sir
ସେଥିପାଇଁ
yes sir
ସେଥିପାଇଁ ଆମେ ପ୍ଲେଣ୍ଟିଫକୁ ପାନିଶ କରୁଛେ।
yes sir
why? Because the defendant could not appear।
right sir
ବଟ୍ ଯଦି ଏଠି ଡିଫେଣ୍ଡାଣ୍ଟ ଆସି ହିଁ ଗଲାଣି,
yes
ମୁଁ
sir
ଯୋଉ ଆପଣଙ୍କୁ ଏକ୍ସାମ୍ପଲଟା ଦେଲି ଦ୍ୟାଟ୍ ଫର ଏକ୍ସାମ୍ପଲ ଆପଣ ଆପଣ ମତେ ମତେ ଗୋଟେ ସିମ୍ପଲ କଥା କୁହନ୍ତୁ, ଆପଣଙ୍କ ଏଗେନ୍ଷ୍ଟ ଗୋଟେ ସୁଟ୍ ହେଇଛି ବୋଲି ଆପଣ ବାହାରୁ probably summons was not served, but ଆପଣ ବାହାରୁ ଶୁଣିଲେ that a suit has been filed against me by my brother or my cousin। ତ
yes
ଆପଣ
sir
ଯାଇକି ନିଜେ ନିଜେ from your own volition you went and attended the court।
yes sir
You getting it? This is what it says, that provided that no such order shall be made, if notwithstanding such failure, the defendant attends in person or by agent when he is allowed to appear by agent on the date। ମାନେ ଆପଣ ସେ ଯୋଉ ଇନ ପର୍ସନ ଏତେ ଗୋଟେ ଲମ୍ବା କରି ଲେଖିଛନ୍ତି ବୋଲି ଆପଣ କନଫ୍ୟୁଜ। ସିମ୍ପଲି ମନେ
ଆଜ୍ଞା
ରଖନ୍ତୁ ଯେ
ଆଜ୍ଞା ସାର୍
ଡିଫେଣ୍ଡାଣ୍ଟ ଆସିଗଲାଣି, ସମନ ସର୍ଭ ହେଇନି ଭୁଲି ଯାଆନ୍ତୁ, ସମନ
ଆଜ୍ଞା
ସର୍ଭ ହେଇନି ଠିକ ଅଛି,
yes sir
ପ୍ଲେଣ୍ଟିଫର ଫଲ୍ଟ ଅଛି ଠିକ ଅଛି, ବଟ୍ ଷ୍ଟିଲ୍ ଡିଫେଣ୍ଡାଣ୍ଟ ଆସିଗଲା। ତ
yes sir
ଏଠି କିଛି ଏରର ହେଇଯାଉନି। ଏରର ତ ସେତେବେଳେ ହେଇଥାନ୍ତା ଯେତେବେଳେ ଡିଫେଣ୍ଡାଣ୍ଟ ଆସିନଥାନ୍ତା, ସେତେବେଳେ ଆପଣଙ୍କୁ ପନିଶ କରାହେଇଥାନ୍ତା ବିକଜ summons could not be served and that is the reason defendant could not appear। That's why
yes sir
court will punish you। But here defendant ଆସି ଯାଇଛି out of his own volition, maybe summons could not be served, but ଠିକ ଅଛି, procedure cannot be the handmaid of justice। justice ତ ହଉଛି ନା। So here the rule says defendant ଯଦି by the way ବି ଆସିକି ପହଞ୍ଚିଗଲା even though summons was not served,
yes
till
sir
then କିଛି ଅସୁବିଧା ନାହିଁ, ଆଉ ପ୍ଲେଣ୍ଟିଫକୁ ଏଠି ଖାଲିଟାରେ ପନିଶ କରିବା ଦରକାର ନାହିଁ। ଯଦି ଏରର ହେଇଥାନ୍ତା ତାକୁ ପନିଶ କରିବା।
then we may say sir it is sir part of exception of rule 2।
yes,
somehow
ଯଦି
it's
ସେଇ
a exception somehow.
exception ମୁଁ ସେଥିପାଇଁ କହିଥିଲି କି ଯେ ଏଠି ଆର ରିକ୍ୱାରମେଣ୍ଟ ହଉଛି ତିନିଟା ସବୁ ରହିଛନ୍ତି ଆର ରିକ୍ୱାରମେଣ୍ଟ ହଉଛି ଯେ ଫର୍ଷ୍ଟ ହଉଛି ଡିପେଣ୍ଡେଣ୍ଟ କୁଡ୍ ନଟ୍ appear ହବା ଦରକାର ଇଟ୍ସ ଏ ମଷ୍ଟ ଫର୍ଷ୍ଟ
Yes sir.
ରିକ୍ୱାରମେଣ୍ଟ ଇଜ ଡିପେଣ୍ଡେଣ୍ଟ କୁଡ୍ ନଟ୍ appear ଡିପେଣ୍ଡେଣ୍ଟ appear କରିଗଲା ତ ସରିଗଲା
ଆଜ୍ଞା
ବୁଝିଲେ
ଆଜ୍ଞା ସାର୍ ଥ୍ୟାଙ୍କ ୟୁ ସାର୍ ଥ୍ୟାଙ୍କ ୟୁ ସାର୍।
any other question we have some new students if there is no question I am willing to be introduced to you some of them Pritiman has a question please ask
Sir, namaskar, sir. Barrett, sir, order 9 रे appearance of parties and constitution of non-appearance. Sir, जो
appearance of
point
party
number appearance of parties and constitution.
which rule
Sir, order 9. Sir, order 9.
order 9 to we know but order 9 to rule
Sir, rule 1, sir.
okay rule 1 what is the doubt
Sir, parties to appear on day fixed in summons for defendant to appear and answer. मतलब एटा point टा बुझ पालिन sir.
ତ ସେଠି ସେ କହୁଛି ଯେ ବଟ୍ ଆପଣ ତ ହେଡିଂ ଟା ସିନା ପଢିକି କହିଲେ ମୁଁ ତ ଆପଣ ପୁରାଟା ପଢନ୍ତୁ ପୁରାଟାରେ କହିଲା ଯେ ଅନ୍ ଦି ଡେଟ୍ ଡେ ଫିକ୍ସଡ ଇନ୍ ଦି ସମନ୍ସ ଫର୍ ଦି ଡିଫେଣ୍ଡେଣ୍ଟ ଟୁ appear and answer the parties shall be in attendance at the court house in person or by their respective pleaders that means ଆମେ ପଢିଥିଲେ ଯେତେବେଳେ କହିଥିଲେ ସମନ୍ସ ରେ ସେଠି କହିଥିଲା ଯଦି ଡିଫେଣ୍ଡେଣ୍ଟ କୁ appear ଆପଣ ସମନ୍ସ କଲା ବେଳକୁ ଡିଫେଣ୍ଡେଣ୍ଟ କୁ କହିପାରିବେ ଯେ ତମେ ଆସ ତମେ ଆସିଲା ବେଳକୁ ଆଇଦର ପର୍ସନାଲି ଆସିବ କି କେମିତି ଆସିବ ସେଟା ବି କୁହାହବ କହିଥିଲା ଆଉ କୋର୍ଟ ଏଇଆ ବି ସେଥିରେ ଗୋଟେ ଅର୍ଡର କରିପାରିଥିଲେ that ଡିଫେଣ୍ଡେଣ୍ଟ ଆସିଲା ବେଳକୁ ପ୍ଲେଣ୍ଟିଫ ବି ରହିବା ଦରକାର
Yes,
और ପ୍ଲେଣ୍ଟିଫ ନଥିଲେ
sir.
ବି ଆଟଲିଷ୍ଟ ଲିଡର ଥ୍ରୁ ତ ରିପ୍ରେଜେଣ୍ଟ ହବା ହିଁ ଦରକାର
Yes, sir.
ସୋ ଏହା ହିଁ କହୁଛି ଯେତେବେଳେ ଆପଣ ସମନ୍ସ କରିକି ଦିଆହେଇଛି ଆଉ ଡିଫେଣ୍ଡେଣ୍ଟକୁ ଡାକିଛନ୍ତି then both the parties must be present it doesn't matter whether in person or in or through pleader that is not
Okay.
material first hearing ବେଳେ both parties have to be present that is what rule 1 says hearing କଲା ବେଳକୁ both parties must be represented either present or be represented through their pleader ଏଇଟା ହିଁ rule 1 କହୁଛି
Sir, rule 4 रे sir जो कहते plaintiff may bring fresh suit or court may restore suit to file. Restore suit to file ला sir ये point what बुझ पाल sir. Plaintiff may bring fresh suit or court may restore suit to file.
ଦେଖନ୍ତୁ ଆପଣଙ୍କୁ ଯଦି ଟର୍ମ ଟା ରିଷ୍ଟୋର ଟୁ ସୁଟ୍ ଟୁ ଫାଇଲ ରିଷ୍ଟୋର ଦି ସୁଟ୍ ଟୁ ଫାଇଲ ତାର ଟର୍ମ ମାନର ମାନେ ବୁଝିବାର ଅଛି ବେସିକାଲି ସିମ୍ପଲି ପୁଟ୍ ଇଟ୍ ୱିଲ୍ ବି ଟ୍ରିଟେଡ୍ ଆଜ ଇଫ୍ ଇଟ୍ ୱାଜ ନଟ୍ dismissed so basically ଆମେ ଗୋଟେ dismissal order କରିଥିଲା କୋଉଠି ଗୋଟେ dismissal order କରିଥିବ that the suit was dismissed why because the neither party could appear or the defendant could not appear because the summons could not be served due to plaintiff's fault 2 3 ରେ ଆମେ କହିଲା 2 3 ରେ ଯାହା ବି fault ହେଇଥିବ ତା ପାଇଁ ଆମେ suit ଟା dismiss କରାଇଥିବୁ ଯଦି suit ଟା dismiss ହେଇଥିବ ତା ମାନେ ଲେଖା ହେଇଥିବ ଯେ suit has been now dismissed ଗୋଟେ order ଟେ ହେଇଥିବ now again ଯଦି application ହେଲା plaintiff ଗୋଟେ application କଲା ସେ ସାଟିସ୍ଫାଇ କରିଦେଲା କୋର୍ଟ ଯେ କଣ ପାଇଁ ସେ ଫେଲିୟର ଟା ହେଇଥିଲା ରୁଲ 2 ରେ କାହିଁକି ସେ ସମନ ସର୍ଭ ହେଇପାରିନଥିଲା କି ରୁଲ 3 ରେ ଯୋଉ ନାଇଦର ପାର୍ଟି ଆପିୟର କରିଥିଲେ ପ୍ଲେଣ୍ଟିଫ କାହିଁ ଆପିୟର କରିପାରିନଥିଲା ଯଦି ଡିଫେଣ୍ଡେଣ୍ଟ ତ ଆସିକି କହିବନି ଯେ ରିଷ୍ଟୋର କରିବା ପାଇଁ ଡିଫେଣ୍ଡେଣ୍ଟ କାହିଁ କହିବ ରିଷ୍ଟୋର କରିବା ଡିଫେଣ୍ଡେଣ୍ଟ ତ ଭଲ ଚାହୁଁଛି କି ରିଷ୍ଟୋର ସୁଟଟା ଯାଉ ପଳଉ ସେ ତ ଡିଫେଣ୍ଡେଣ୍ଟ ଚାହୁଁଛି ବଟ ଯଦି ପ୍ଲେଣ୍ଟିଫ ଏଠି ଫାଇଲ କରୁଛି ଦ୍ୟାଟ ରିଷ୍ଟୋର କରାଯାଉ ଦେନ୍ ତାକୁ ଫାଇଲ ଟାକୁ ରିଷ୍ଟୋର କରିବା ମାନେ ହେଉଛି ଆପଣ ଯେ ଫାଇଲ ଟା କୁଆଡେ ପଳେଇଥିଲା ଥୋଡି ବଟ ଫାଇଲ ଟା ରିଷ୍ଟୋର କରିବା ମାନେ ଅରିଜିନାଲିଟି ରେ ଆଉଥରେ ପ୍ଲେସ୍ କରିବେ ଆଗରୁ ଯଦି ଡିସମିସ୍ କରିଥାନ୍ତେ ଆପଣ ଡିସମିସ୍ କରିକି ରଖିଦେଲେ ବଟ ଏବେ ଫାଇଲ ଟାକୁ ଆପଣ ଆଉ ଥରେ ଦି କୋର୍ଟ ଇଜ ବାଉଣ୍ଡ ଟୁ ଏଣ୍ଟର ଇଟ୍ ଇନ୍ ଦି ଡାଏରୀ and enter it in the regular course of business. The regular course of business to apply.
Okay, sir. Thank you, sir.
Right. Any other doubt?
सर सफिशिएंट कॉज कौन हे परियो कि जान परियो कि माने केमती कौन कौन गुडा को सिचुएशन सफिशिएंट कॉज रे आसियो
See, as I told you, the situation might vary. बहुत vary କରିପାରିବ ମୁଁ ତ ଯେମିତି କହିଲି କୋଭିଡ the the ongoing COVID that is there, that can be a sufficient cause. But what cannot be a sufficient cause? ସେଟା ବି ଆମେ ପଢିବା ଆମେ କଣ କଣ sufficient cause ନୁହଁ so ଏଇ କେସ ରେ sufficient cause କିଛି ନାହିଁ କଣ ଅଛି ସେଟାକୁ କିଛି ହେଇନି but court must deem ଯୋଉଟାକୁ sufficient cause ବୋଲି court ଭାବିବ ତାକୁ କରିପାରିବ but ବହୁତ ଗୋଟେ ଜାଗାରେ sufficient cause define ହେଇଥାଏ ଯେ these all will be sufficient cause and in that case ସେଇଟାକୁ ଆମେ sufficient cause କରିବୁ but in this case ଏମିତି କିଛି sufficient cause define ହେଇନି sufficient cause will be what court considers it sufficient court ଭାବିବ ଯେ ହଁ ମତେ ଲାଗୁଛି କି this is reasonable, this is a reasonable ground why the plaintiff could not appear on the date fixed, and that's why it was dismissed. And let's just give him another chance, because तार merit अच्छी जहाँ भी अच्छी हमें ताकू न शुणी dismiss करिया. Normally courts are not inclined to dismiss your matter, but this is given as a गोटे ताकू गोटे माने power दिया है जी court को, so that आपण सेठी foul play करि परिबे, court रे case टा कर दे कि आपण पळेबे. That is what is not encouraged. तो कोर्ट सबले ट्राई करिवो आपन को जते आपन डिसमिस हेछि आपन रिस्टोर पे अप्लाई करंतु. Sufficient cause, we normally courts construe it very liberally, that sufficient cause, okay, this is a sufficient cause, let's just construe it liberally and let's just grant him the order of restoration. But this is just a power given to the court, so that people should not take court lightly and be serious about their case. ଏଇଟା ପାଇଁ ଆପଣ sufficient cause କିଛି define ହିଁ, but it can be varying from case to case. ଆପଣ sufficient cause ଏବେ, for example, according to me, if you ask me what is a sufficient cause, COVID is a sufficient cause. But sir, ମୁଁ କାଲି ମୋର train ticket ଟା ହେଇ ପାରିଲାନି, ତତ୍କାଳରେ କରିଥିଲି confirm ହେଲାନି, and there was n number of ways to come. ଆପଣ car ରେ ଆସିପାରିଥାନ୍ତେ, bus ରେ ଆସିପାରିଥାନ୍ତେ, ଆପଣ train ହେଲା ହିଁ ଆସିଥାନ୍ତେ ନା କଣ? So if I was a court, I would not take this as a sufficient cause. So to define any what is a sufficient cause, you have to satisfy, and the court is to be satisfied that yes, this is a sufficient cause. Okay, Abhishek has a doubt.
So we discussed in rule 4. So regarding there are certain cases where a fresh suit can be filed, and there are certain cases where it cannot be filed. So, but is there a list on it given anywhere?
List not, I mean, not given anywhere, but I'll round it up for you. At the end of the discussion of Order 9, I'll round up the cases where you can file a fresh suit, and in the cases you cannot file a fresh suit, in Order 9 at least. And
So
we'll
because you
proceed.
said that it comes in question, so that is why I asked. So
Yeah, I'll tell you. I'll tell you. Please bear with me, and I'll tell you when the time comes.
sure,
Okay?
sir. Thank you, sir.
Thank you. Okay. Time for introduction. We have some new faces. I mean, no faces here, but new names. So Arindam Banerjee, please introduce yourself. Arindam Banerjee, sir, if you're there, please introduce yourself. Okay, too shy. Too shy. Binay Bhushan Das. Why are guys shy? Please tell me. Tell me. Binay Bhushan, please. Pritiman, do you have a question?
Yes, sir. I am having a question, sir. I usually visit to High Court. I have seen that the justice asks us that time limit has barred. You can't file the suit, sir. If you satisfy the court that condemnation of delay, then also the suit can't be filed. What are the मान को प्रोसीजर रे सर कोर्ट को satisfy कर पाले जे हमें सूट टा फाइल कर पाबे.
So you are telling me that what reasons can you give to the honorable court so that you can take time?
Yes, sir.
I think I'll be the last person, because I'm on the other side of the bench up to now, so I don't think I'll be giving you the list. But till then, you can try your luck, and please do not take any honorable justice's name. They have their own reasons why they do not allow time. The pendency of the Indian judicial system is so huge that probably we should construe it very strictly. But then, nevertheless, we are construing it liberally. But ମୁଁ କହିଲି ଆପଣଙ୍କୁ ଯଦି ସେମିତି practical example ଦେବି କଣ sufficient cause, ଆପଣ କହିବେ counsel is ill, and for that you may take a time. No one will give you that time. କୋଉ ବି sane person will not give you time. But ଆପଣଙ୍କୁ sufficient cause ମୁଁ ଆପଣଙ୍କୁ କହିପାରିବିନି କେମିତି, but if there is मेडिकल सर्टिफिकेट दैट आपनकर माने कोन पई एई पीरियड रे आपन दी your party was bedridden and hence he could not produce certain documents to you. In that case, that can be sufficient. See, it varies from case to case, as I told you. There is no exhaustive list that eight is sufficient cause or eight is sufficient cause. And there is always, it's a subjective matter. There is no objectivity affixed here. So it can be very subjective. It can go up to any extent. So ଆପଣଙ୍କୁ ଏଠି ମୁଁ list ଦେଇପାରିବିନି, but nevertheless, ଆଉ କିଛି question or ଆଉ କିଏ ଆନ୍ସର କିଛି ଆଉ କାହାକୁ ଇଣ୍ଟ୍ରୋଡ୍ୟୁସ ହେବାକୁ ଥିଲା ମତେ. People are not being introduced. Subhecha Patnaik. Subhecha Patnaik. Please introduce yourself.
Sir, I am from the D Law College.
Okay, great. And which year are you studying?
Sir, I am 5 years integrated law second year.
Great. Subal Gardia. Please introduce yourself.
Good evening, everyone.
Great.
My name is Subal Gadia and practicing at Sambalpur district bar and also pursuing my LL.M in MS University Cuttack at present.
That is great. That is great. We also have Partha Sarathi Mahakul. Please introduce yourself. Partha Sarathi sir, if you're there, please introduce yourself. Manas Sahu sir was there yesterday. I asked, but Manas Sahu sir did not respond. So please,
Sir,
please,
myself Manasundan Sahu.
yes.
I am practice an advocate in the Chandipur court.
Oh, great. That is my hometown.
Sir,
Uh, I am from Jarka, if you know.
sir.
So, okay, okay, great. It's nice to
Thank you.
come across you as well. Okay, so it's almost late, and we'll end the discussion right away. If anyone has any question, no. Okay, we'll end the discussion right away. Thank you. We'll continue with Order 9, rest of the rules, and I'll give you the roundup as I promised that those three circumstances, as I told you, I'll give that roundup as well. Thank you. Have a great night.